I think so. I think so.
Omaikako and good morning. It's Monday, April 5th, 2021. Welcome to today's 9:30 a.m. AEN-WTL-GVO-JDC-WAM Joint Committee hearing in room 211 and virtually, of course, which will include audio and video of remote participants, and it's being streamed live on YouTube. You'll find the links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website at capitol.hawaii.gov. And a few housekeeping announcements. If we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business at 1:01 p.m. on April 9th during our AEN via video conference time slot, and there'll be a public notice posted on the legislature's website. And for testifiers, all testifier audio will be muted and video disabled until shortly before it's your turn to testify. And because of our 90-minute time limit for each of the AEN hearings, there'll be a 2-minute time limit for all testifiers, and we'll have a virtual countdown timer on the Zoom screen, so please be aware of the timer. I'll be announcing only the testifiers who will be providing testimony via Zoom, and for the complete list of testifiers, along with all the written testimony, please go to the legislature's website, and you'll find a link on the status page for the measure. We apologize if the closed captioning does not accurately transcribe the names, so let's get started. We have one bill on our 9:30 a.m. agenda, HB 1318 HD1, relating to sustainability. Let's see, it establishes the Environmental Advisory Council, transfers the rights, powers, employees, appropriations, and other personal property from the Office of Environmental Quality Control to the Office of Planning. Amends the ability for an applicant to appeal non-acceptance of an environmental impact statement from the Environmental Council to the Environmental Advisory Council. Okay, so first up on our testifiers, we have the Department of Health. Anyone from DOH?
Good morning, chairs. Good morning, committee members. Keith Kawaoka, Acting Director for the Office of Environmental Quality Control, testifying in support. And we stand on our written testimony and be available for any questions. Thank you.
Mahalo, Keith. Next up is Mary Alice Evans and Danielle Bass from OP, Office of Planning.
Good morning, Chair Gabbard, Chair Inouye, Moriwaki, Rhodes, and Chair Dela Cruz. The Office of Planning supports HB 1318 and stands on our testimony offering one amendment. And thank you very much for the opportunity to testify.
Thank you, Mary Alice. And next is Onau Nathun from the State Environmental Council.
Great. Aloha, Chair Gabbard and members of the various committees. Thank you for the opportunity to testify on this bill. I do want to note that our written testimony was on HD1, which is posted on the website. In the meantime, Senate Draft 1 has been shared with us. So some of our testimony, our written testimony, is no longer applicable. I did want to just, send a thank you out to Senator Gabbard, Representative Lowen, and Senator Moriwaki for working with the council this legislative session to hear some of our asks, and they're in this bill. With respect to Senate Draft 1, which does actually provide that applicant appeals of a non-acceptance of an EIS goes to the Office of Planning, the council is generally supportive of the HD1 draft, which deleted that requirement altogether and would allow for applicant appeals to be done in the same manner as those challenging an acceptance of an appeal through the court system. But to the extent that OP is supportive of it, the council can be supportive of it. My only comment would be for these committees to consider amending the 30-day deadline in HRS 343-5 to extend that timeline, because the council recently went through an appeals process, and that 30-day deadline on an EIS is extremely quick, and it's extremely challenging for any agency to complete an appeal in 30 days. So with that, again, thank you for allowing me to testify, and I'm available for any questions.
Thank you, Nana. Okay, that's it on the testifiers. Members, any questions? Hang on here, let me see. All right, I have a question. Oh, go ahead. Anyone?
I have a question for Onana.
Okay.
Um,
Senator Acosta.
Do you see anything problematic for the Environmental Advisory Council, kind of staffed with at least 9 representatives representing industry and development in terms of being able to make meaningful environmentally related decisions when we have real estate, visitor industry, construction, architecture, engineering, environmental consulting, and media as main members in this advisory council?
No, I don't think there's a conflict or it's problematic. I think it's great that we do have a council that represents so many different industries and interests. In addition to those that you named, Senator Ocasio, there are also members from, community groups, environmental groups, and the way that I read the statute, HR Chapter 341, which created the Environmental Council, the council is meant to represent these various interests. And, in part of the reason the council is supportive of HB 1318 is the fact that it proposes a reorg which really gets land use planning and environmental considerations in the same place. And I am supportive of that generally. I think we need to make sure that we're balancing all of those considerations in land use planning, environmental considerations generally, because sometimes, those considerations are siloed. And there are so many different demographics that need to be represented. So, I think at times it is, there's a push and pull, of course, but it's great to have that. And we saw that in our rules update that we completed in 2019. There were some provisions that, got, I don't want to say heated, but we had, very deep discussions on, and we had great discussions on them because we had so many people from different, representing different interests and demographics.
And so 9 out of 15 being industry related rather than environmentally feels fair to you?
Apologies, I was still on mute. I don't know if that's the correct, if you're looking at our current membership, and maybe that's the case. Now the statute just identifies having folks from various industries. It doesn't identify that you have to have one person from every single thing. So that makeup can certainly change. I would say that all of our discussions, at least in my time on the council, we have, in my opinion, we have been able to balance, regardless of the numbers. And we have those good considerations.
Okay. Anyone else?
Chair,
Yes.
the proposed draft has 11 members and not 9.
Oh, it went from 15 to...
Yeah, so from 15, it has been dropped down to 11. So it's 9, and if you look on page 6 and 7, so anyway, just a correction, but the proposed has 11 members.
Just to,
Okay. Anyone else?
Chair, just to clarify with Ona, the current membership now is 11, is that correct? And you wanted to keep it at the current membership level?
Yeah, so I'm looking at the copy of a Senate draft, one that was shared with us over the weekend. And it still notes that it would be allowed to be up to 15 members. So I'm sorry, I'm not seeing where it says, at least the draft that was shared with me over the weekend.
Okay.
Still says that we can have up to 15 members. And we're supportive of keeping that number because the statute, it states that you can have up to 15 members. It doesn't say that you have to have 15 members.
So 15 members currently, and you want to keep that number?
Yeah, so we currently have 13 members on the council. We do have 2 vacancies at the time, but having the full membership, I'm supportive of allowing us to have up to that. We did have full membership of up to 15 when we were doing the rules, and that was extremely helpful because the rules update was a lot of work. We also have 5 subcommittees that we work on, and allowing us to have 15 members means that everybody doesn't have to serve on more than 2 committees, so we can really spread the work out.
Okay, thank
Senator
you.
Rivera.
Did you call me? Aloha.
You had your hand up.
I did, thank you. Thanks, Onana. Hi, how are you today?
Doing well, thank you.
You're the answer, lady. All the work that was put into amending the rules, could you give us an update on the status? Have they all been adopted or status of that? And does this structural change affect it in any way?
Right, so all of the rules were adopted in, I believe, they went into effect August of 2019. So we've been operating them for, about a year and a half now. To my knowledge, they've been working well so far. In actuality, I think there are still a lot of projects that are operating under the old rules due to when the new rules took effect and depending on where your project goes. But from what we've heard so far, the projects operating under the new rules, I think there have been at least a couple. So far, so good. And moving OEQC and the council over to OP, I would imagine we would have to do, some kind of repeal and readoption of the rules into a new chapter. Currently, the environmental impact statement rules are under, Title 11-200.1. So we'd have to move it over to OP, but I don't foresee that being too difficult. I'm sure that there are procedures for doing that.
So they would still be functional. They wouldn't. They don't have to go forward at the same time as this change, or in advance of.
In advance of, I guess.
Any chance that it gets stuck into this black hole? Well.
Yeah, that is a good question. I would like to actually consult, I don't have our AG on, but I think that's something procedurally we would have to consult with our AG and how would we move the department over and move all of the rules over at the same time so that there's no gap essentially.
Yeah, especially after all the hard work everybody put into getting the rules in a better place.
Right.
I have one more question if I may.
Sure.
Go ahead. Thank you. So this it seems like a little bit of a ping pong going back and forth, Onana. The request for consideration of denial of EA, that little clause, and can you kind of restate that, elaborate on that a little bit? Because the last draft said, well, if it's denied, you have your recourse in court, but this one it sounds like it's putting it back in. How does that affect it? And if you're going to allow the people to ask for reconsideration on denial, should we also consider asking consideration on approval?
Sure.
Same process either way.
Right. Thank you, Senator Rivera, for that question. And I think that highlights, some of the reason why we went in and requested this in the first place. For those of you who aren't as familiar with the council and the council's work, we do hear appeals of non-acceptance of EISs specifically. So just applicant appeals if their EIS is not accepted. Now, this provision really hasn't been used a lot over the course of the last 30 years. The council received its first, appeal through end and decision just late last year, in summer of last year. Prior to that, we are aware of one situation where the appeal process was started, but at some point the parties settled. So it's not a utilized provision very often. And so when this came to the council, of course, it was something that we had, a vast learning curve to have to go through. And as we were looking at it and actually going through the process, we did some research on our own legislative history, and we couldn't find much in the legislative history of why does this provision exist in the first place. Perhaps it's because the legislature wanted to provide some sort of process that was a little bit quicker for applicants to go through in the event that their EIS was rejected. But in thinking about it more, and looking at the statute, HRS 343.7C already provides a process for how you appeal an acceptance of an EIS, right? And from a due process standpoint, it's the council's opinion that that process would be, it's more fair to have the same process for applicants who are denied an acceptance of an EIS to appeal in the same manner that somebody appealing an acceptance of an EIS. If to go to your question, Senator Rivera, so if this provision stays and we have an administrative process now, should applicants or should those challenging an acceptance now be able to go through an administrative process? From a fairness standpoint, that makes sense, but I wouldn't personally be supportive of it because really, we're thinking you should already have the same process that's in 343.7. Again, you're creating more work for the agency to have to go, look at these these acceptances and non-acceptances in these appeals. And to have another agency who's not really involved in the permitting process and really delving deep into, you know, the science that was used to support the EIS, what studies were appropriate, et cetera, reviewing another agency's decision, is that, you know, perhaps the right thing to be doing? There's a question about that. So your point is well taken, again, and that's why, you know, we had initially approached certain legislators to say, hey, can we amend 343, delete the provision in 343.5E, allowing for appeals of non-acceptances to come to the council and let applicants have the same process as those of the general public.
Thank you for your testimony. It's very, very well said.
Okay, thank you.
Chair, I have a question going back to the question about, that Senator Rivera had about whether the rules transfer over. I think, yes, just to clarify, and maybe Mary Alice can respond to this, if she's still there, Office of Planning. So that if all of the rights and responsibilities of both the Environmental Council and the OEQC is transferred over to Office of Planning, would not those same rights in rulemaking, because the Advisory Council now will be still responsible for rulemaking regarding 343, would not all transfer over and they would still be responsible for rulemaking?
No.
Huh?
Read her testimony.
Mary Alice?
Yes. Senator, thank you for the question. Our two AGs have reviewed the HD1 and had no problems with it. I don't know that we've addressed specifically the question of when the rules would transfer over, but subject to AG's advice, I'm assuming that they will remain in force in the Department of Health title until they can be transferred over, so no gap. And since the rules were just recently redone, OP would defer to the council on any ideas about making changes. We defer to the council also on the question of whether there ought to be an administrative process before going to the court. So we support the council's position on that. Thank you, Senator. Thank you, Chair.
Chair Gabbard, I have a question.
Yes, Senator De La Cruz.
So Mary Alice, your testimony talks specifically about including the rulemaking. So if we were to include the language of your testimony, should we also include that the council's rules shall transfer over and just make it explicit?
That might be helpful. Thank you.
Why don't we do that?
Thank you.
Okay. Anyone else? All right, at this time, we will go into the breakout room. Thank you, members.
Actually, Chair, I still have another question. Thank you. For Anna. I might have a few. So I'm wondering how often does the environmental review process turn out finding of no significant impact? Is it rare? Is it typical, especially these days?
Sure. Thank you, Senator Ocasio, for that question. You know, I'm not the best person to answer that. The Environmental Council is not an accepting authority. Neither is OEQC for any environmental review documents. We're exclusively responsible for promulgating the administrative rules, as well as hearing applicant appeals currently. We also work with, reviewing agency exemption lists. So I unfortunately don't have those statistics for you. It's just not something that the Environmental Council tracks.
Okay. Also, you mentioned that there was lots of lively discussion and it turned out to have really good impact when we had really contentious issues on the Advisory Council. Being that the Advisory Council is, my understanding would be to protect the environment, whereas many, looking like a majority presence on the Environmental Review Council, according to this Senate draft that we're currently speaking of, they have, they profit off of, or aren't necessarily taking into consideration environmental protection. And so when I look at the makeup that Senate Draft 1 is is proposing, it really concerns me. And I would like to know, how do members of the advisory council conflict themselves out when they work for example, a law firm that represents, business development, real estate, or maybe they're realtor, et cetera, et cetera. So basically looking to me like it's a skewed council, very clearly not in the protection of environmental, environmental protection advisory. And so how do folks conflict themselves out when they really represent, profiting off of that?
Sure, thank you for that question. So just as a starting point, the Environmental Council, among its many roles, is to consider the environment and protection. I wouldn't say that's exclusively its role. And, the environmental impact statement rules, when you look at what they're for, it's to provide a process for balanced considerations of many things, including environmental protection, not alone. But to your narrow question of how do folks conflict themselves out if an issue comes up, we do have a process for considering conflicts, like most boards and commissions. If somebody has a particular interest in a matter that's being heard by the council, we have to disclose it, and there's a recusal process as well, and that's taken into consideration. I will, for these committees' benefit, there aren't many matters, again, that the council hears where we have decision making. The appeal that came before us, this past year was really the first for real decision making in terms of how does it impact particular rights of, a developer or whatnot. In that case, we did have motions. 3 members recused themselves from the process who may have had interest in the matter. Other than that, we do the administrative rules, which, have broad application to many in the state. And then we also here, we work with the agencies on exemption lists and whatnot. So, but in the event, if there is a conflict, of course, the members have to disclose it and recuse as they would, in any board or commission.
So you might as well switch it over.
Okay, thank you very much. IT, if we could go to the breakout room for some discussion. Okay, reconvening the 9:30 joint hearing of AEN, Water, Land, GVO, Judiciary, and Ways and Means. The chairs having conferred, and we need some more time just to take a closer look at some of the amendments that we're discussing. So I'd like to reconvene at 1 p.m. today, April 5th, Monday, at the regular hearing time for AEN. So 1 p.m. in 211 and on video conference. Okay? See you then, folks.
Thank you.
Convening, aloha and welcome, convening the joint hearing of the Senate Committees on Government Operations, Judiciary, and Ways and Means. Today is Monday, April 5th, 9:45 a.m. We are in conference room 211. Before proceeding with the hearing, a few housekeeping announcements. This hearing is being streamed live on YouTube. You can find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we encounter major technical difficulties, today's hearing must end abruptly. The committee will reconvene on Thursday at 10 a.m. in room 211. We are looking at House Bill HH2, House Draft 1, Senate Draft 1 this morning, relating to procurement, requiring purchasing agencies to make written determination that amount of contracting action for purchases of health and human services is fair and reasonable, amends the selection process and composition of procurement policy board, and amends we have had some discussion that we would like to amend this procurement bill by also adding in language that is also relevant to efficient procurement in Senate Bill 1329. So the chair recommends that we defer this hearing until
Repost.
and repost it for Thursday, 10 a.m. in room 211. Questions, members? So we shall.
And by video conference.
So, yeah,
Is there anyone here this morning wanting to testify on this measure?
No, it's DM only now.
we're going to,
Oh, this is DM?
Yeah,
Okay.
so now we're going to turn it into a hearing on Thursday.
Okay.
on Thursday.
Thank you.
Okay. With no other business today, we will adjourn.
Aloha everyone. Welcome to a joint hearing on the Committees on Labor, Culture and the Arts and Committee on Ways and Means. Today is Monday, April 5th, 2021. It is 10:30 a.m. and we are in conference room 211. We have one bill today, but prior to that, so we'll do housekeeping. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You'll find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committees will reconvene to discuss any outstanding business. I believe today at 3 p.m. In room 225 or 3 in this room.
So do you have a 1 o'clock?
Oh, yeah.
Yeah,
Just combine it for 1 o'clock if there's a problem.
yeah. So 105. Okay. Instead of 3 p.m., we'll go 105 in this room at 211. Did you want to introduce all your guys, or can we just go? Okay. So we have one bill, House Bill 468, House Draft 1. This is relating to the Hawai'i Employer Union Health Benefits Trust Fund. It suspends the requirement for public employers to make annual contributions to the Hawai'i Employer Union Health Benefits Trust Fund through fiscal years 2024-2025. Members, you should have been posted proposed Senate Draft 1, and so that's what we'll be dealing with today. As far as testifiers, we have the Department of Budget and Finance, Mr. Hirai.
Good morning, Chair Taniguchi and Chair Dela Cruz and committee members. I'm Craig Hirai, Director of Finance. You have passed this bill in a former vehicle, Senate Bill 1087, previously. This bill temporarily suspends the requirement for public employees to make annual required required contributions to the Hawai'i Employer Union Health Benefits Trust Fund through fiscal year 2025 and the associated general excise tax clawback if annual required contributions are not made. Based on the most recent actuarial evaluation report for the state's OPEB as of July 1, 2020, suspending OPEB pre-funding payments for all 4 years will reduce fixed costs by $1.4 billion over the same period. While this bill will temporarily suspend OPEB pre-funding, it also enables the state and counties to make partial pre-funding payments at levels below the actuarially determined amounts as a result of suspending the GET clawback. BNF will be working with the counties to determine whether they will be in a position to make some level of pre-funding payments in the future. Thank you for the opportunity to testify, and we're available to answer any questions.
Thank you, Mr. Hirai. We have the Hawaii Employer Union Health Benefits Trust Fund, Mr. Mizuno.
Hi, good morning. Derek Mizuno, ETF Administrator. I'll stand on my written testimony, providing comments, and I'm here for any questions. Thank you.
Thank you. We also have two other testimonies, one in support from the City and County of Honolulu, and comments from the Grassroots Institute of Hawaii. Do we have any questions from members? If not, I guess Chair had a quick question for Mr. Hirai. Given the federal aid that we've gotten, do we still need to do 4 years?
Yes, because of the financial plan and our bond rating. Right now, this would create a $1.4 billion, or potentially create a $1.4 billion hole in the financial plan, which may lead to negative general fund balances in the out years. It would be safer to maintain the flexibility of making partial payments, or the ability to make partial payments under these circumstances, because we can't see what's in the future.
Okay. Do you have an estimate of how much partial payment you might be able to do?
A couple of things. We want to consult with the counties first, but for example, rather than the whole payment, for example, if we did $100 million a year for each of the 4 years, that might be manageable under the financial plan, and that would take care of 1 year's funding.
Okay. Thank you. Any further questions from members? If not, we'll recess the public hearing, go into the break. Welcome back. This is the joint hearing on with the Committees on Labor, Culture and the Arts and the Committee on Ways and Means. We had one bill. This is House Bill 468, House Draft 1, proposed Senate draft. We both chairs have discussed this quite a bit, and we
Labor one.
Labor one. Yeah, right. We will include the contents of Senate Bill 1087. 1087.
No, just the study you said.
Right.
Oh, the SD you mean.
Yeah, so SD1. And we will also include a study that the EUTF will do to report back to us on
The
this,
original contents, yeah.
the original contents of House Bill 468, House Draft 1. Any discussion? If not, for the Committee on Labor and Culture and the Arts, the recommendation is to pass House Bill 468, House Draft 1, with amendments. Chair votes aye. Vice Chair is excused. Senator Chang.
Aye.
Senator Keokalole.
Aye.
Senator Favela.
Aye.
Thank you.
Oh, same recommendation, Ways and Means. Chair votes aye.
Vice Chair votes aye. Senator English. Senator English?
Aye. Aye.
Senator Inouye?
Aye.
Senator Kanuha?
Aye.
Senator Kidani?
Aye.
Senator Moriwaki,
Aye.
Senator Shimabukuro,
Aye.
Senator Taniguchi,
Aye.
Senator Wakai,
Yes.
Senator Favela.
Aye.
The recommendation is adopted.
Thank you.
Thank you, members. Thanks, Chair.
That was fun. Yeah. Okay, calling to order the 10:35 agenda. We're going to defer this item to Wednesday, 10:35 a.m. in this room. So HB 243 will be deferred to Wednesday, 10:35 a.m. in this room. Adjourn.
Okay, aloha kako, everyone. We are reconvening the decision-making on this morning's 9:30 agenda, joint agenda on 1318 AEN, Water, Land, Government Operations, Judiciary, and Ways and Means. And so first off, I want to say mahalo to the GVO Chair, Senator Moriwaki, for her work on this bill. Colleagues, this bill will improve the coordination of land use planning and permitting by enabling greater efficiencies and sharing of limited resources to better achieve the state's environmental quality and sustainability goals by transferring the purpose, functions, duties, staff appropriations, and property of the Office of Environmental Quality Control from the Department of Health to the Office of Planning. So the chairs have conferred, and the recommendation will be to pass HB 1318 HD1 with amendments. Colleagues, please note, nearly the entire Senate in this hearing. And it's not possible for us to get 100% agreement of all members. So I'm asking you to vote your conscience, and then we can make up any additional changes in conference committee if necessary, okay? So let me just go through these amendments. We'll amend the section of the bill relating to the Environmental Council to create the Environmental Advisory Council under HRS 341, HRS 341-6, and HRS 343-6, and transfer the Environmental Council from the Department of Health to the Office of Planning. Next, we'll amend the definitions to reflect the changes to HRS 343-2 for council, quote-unquote council, to mean, quote-unquote Environmental Advisory Council, director, quote-unquote, to mean, quote-unquote Director of the Office of Planning, and quote-unquote office to mean, quote-unquote Office of Planning. And we'll add environmental review under HRS 343 to the Office of Planning's responsibilities under HRS 225M-2B11. We'll alleviate the Environmental Council's annual reporting requirements on statewide environmental goals and policies under HRS 343-6 by requiring the Office of Planning to include the Environmental Council's annual report and recommendations in Office of Planning's annual report to the legislature. Next, in light of the concerns surrounding the non-acceptance of final EISs from the Environmental Council to the Office of Planning, we'll keep the existing HD1 language. And although there have been concerns about whether the administrative remedies would be properly extinguished before claims are appealed to the Environmental Court, an applicant for an environmental impact statement would still provide their statement to the accepting agency for review. Next, deleting the language in Section 19, Subpart 9, that provides that the Environmental Council shall adopt rules and shall prescribe procedures to appeal the non-acceptance of an environmental impact statement to the Advisory Council. And this language is proposed by the Office of Planning after its review by its Attorney General representative. Because the process of appeals of non-acceptance of an environmental impact statement is being moved out of the Environmental Council and to the Environmental Court, this language may be deleted from section 343-6 HRS, which provides for the rules of the Environmental Council. Next, restoring section 341-2 HRS, amending the definitions of council, quote unquote, to mean, quote unquote, Environmental Advisory Council, director, quote unquote, to mean director of the Office of Planning, quote unquote, and office to mean Office of Planning, and repealing the definitions of center and university, quote unquote. And then next, we're providing that the Environmental Advisory Council shall be consulted by the Office of Planning in the promulgation of rules under Chapter 91, HRS. This amendment was offered by Senator Riviere, and this change allows for proper deference to the Environmental Advisory Council. Although their name is now being amended to be considered an quote unquote advisory council, this section mandates for OP, Office of Planning, to provide the Environmental Advisory Council the appropriate weight. Next, inserting in language that all rules, policies, procedures, guidelines, and other material adopted or developed by the Department of Health, Environmental Council, or the Office of Environmental Quality Control to implement provisions of the Hawai'i revised statutes that are reenacted or made applicable to the Office of Planning by this act shall remain in full force and effect until amended or repealed by the Office of Planning pursuant to Chapter 91, HRS. In the interim, every reference to the Department of Health, the Environmental Council, the Office of Environmental Quality Control, the Director of Health, or the Director of the Office of Environmental Quality Control, and those rules, policies, procedures, guidelines, and other material is amended to refer to the Office of Planning, Director of the Office of Planning, Environmental Advisory Council, or Chairperson of the Environmental Advisory Council as appropriate. And then this language alleviates the concerns that the rules are appropriately transferred to the Office of Planning from the Department of Health and shall remain in full force and effect despite the transfer. And then we will also update the purpose clause to reflect these changes. And we'll leave, as I mentioned before, we'll leave the defective date July 1st, 2050 to continue the conversation in conference committee. And also there are some tech amendments. Okay, so any concerns? Again, please, if you have some, take them up in conference. Hearing none, chair votes aye, vice chair Nishio.
Sorry.
Oh.
I do have some concerns.
Aye.
Not so much with the merger, but just some of the language within. I would like to see the preservation of references to environmental quality control. Also, the use of the name Environmental Quality Control Advisory Council rather than taking out the quality part. I'm not quite sure why we're removing the quality part of it, because the reason for this is the whole purpose of the statute is to maintain optimum quality of the environment of the state. So not quite sure about that removal of that language. I also had sent in suggestions for Section B that refers to the members on that advisory, Environmental Advisory Council, to incorporate the actual purpose of the original statute. Instead of saying it's for broad and I think it was broad and diverse representation, but actually to incorporate the purpose of the statute, which was to ensure optimal quality of the environment is maintained through a balanced representation of environmentally pertinent interests, and then such as natural and social sciences, education and research institutions with environmental competence, sustainable business practices, land conservation and stewardship, pollution prevention and waste reduction. These things rather than the members which are in there, which are pro-development. Because right now, the way I see the council representation is as it will give a majority of votes to individuals who profit off of the exploitation and degradation of the environment, especially being pro-development rather than pro-environment. So I'm curious, it's very curious to me as to where the pro-environment piece to this is. At any rate, continuing that one section is the members of the Environmental Advisory Council shall serve without compensation, but shall be reimbursed for actual expense and necessary expenses, including travel expenses incurred in the discharge of their duties. So I just wanted to have that on record because I feel like it's important that once it goes to committee, that those considerations are incorporated. Mahalo.
Thank you, Senator Ocasio. And as I said, we will take those up in conference as we confer with the House. Any other concerns? Okay, for AEN, Chair votes aye. Vice Chair Nishihara.
Aye.
Senator Ocasio.
Reservations.
Senator Rhodes.
Aye.
Senator Favela.
Reservations.
Thank you, members. The measure passes. AEN, Senator Inouye for Waterland.
Thank you, Chair. Same recommendation is to pass with amendments on HB 1318, House Draft 1, Senate Draft 1. Any discussions? Seeing none, hearing none. Vice Chair Agaran for the vote. Chair goes aye.
Recommendation to vote is to pass with amendments. Vice Chair votes aye. Senator Misalucha.
Aye.
Senator Revere.
Aye.
Senator Favela.
Reservations.
Thank you.
And for the Committee on Government Operations, Senator Moriwaki.
Thank you. Same recommendation for the Committee on Government Operations. Chair votes aye. Vice Chair Dela Cruz.
Okay, Vice Chair votes aye. Senator Chang.
Aye.
Senator Gabbard.
Aye.
Senator Favela.
Reservations.
Recommendation adopted.
Thank you. And for Committee on Judiciary, Senator Rhodes.
Same recommendation, JDC members. Any questions or concerns? If not, I don't see my vice chair unless he's in 211. I'll take the vote. I'll vote yes. Senator Keokalole is excused. Senator Ocasio. Senator Ocasio, reservations?
Sorry, reservations.
Reservations? Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
And Senator Favela with reservations.
Reservations.
Thank you.
Okay, thank you. And then Ways and Means, Senator Dela Cruz.
Okay, same recommendation for Ways and Means to pass with amendments. Chair votes aye.
Vice Chair votes aye. Senator English.
Aye.
Senator Inouye.
Aye.
Senator Kanuha.
Aye.
Senator Kidani. Excused.
Yeah.
Senator Moriwaki.
Aye.
Senator Shimabukuro. Excused. Senator Taniguchi. Excused. Senator Wakai.
Yes.
And Senator Favela with reservations?
Yes, reservations.
Okay, thank you. Your recommendation is adopted.
Thank you, everyone. And this concludes our decision-making.
Wait, hi, Senator Gabbard, sorry. Maybe we do the AEN hearing, please?
Pardon me?
The voting, please. The AEN voting, please. We missed the voting on the YouTube. The audio got cut off.
Oh, the audio got cut off. Okay, yeah, it was Senators Favela and Ocasio with reservations. And the other three were ayes. Shall I take the vote again?
Yes, please.
Okay. So on HB 1318 for AEN, Chair votes aye. Senator Nishihara?
Aye.
Senator Ocasio?
Reservations.
Senator Rhodes? You already leave? Senator Favela?
Reservations. Senator Gabbard, I got a question. If the audio was cut off on our voting, was the noted that Senator Ocasio spoke of, was that noted? Or was that cut off?
I think the vote was off.
Just the vote.
just the vote part.
So I think Carl's gone, but we have the required 3 votes. Okay, IT?
Thank you, Senator. Sorry about that.
That's okay. All right, members, thank you very much. Aloha.